Motions are sealed, but News Channel 5 has learned that Ranking's attorneys will, in fact, argue the insanity defense. The argument is he may be sane now, but he wasn't at the time of the shooting.
Competency to stand trial is a moving target. It determines whether the person presently possesses the capacity to defend himself in a court of law.
When you consider there is no question Reinking is the shooter, the evidence against him is overwhelming with security video and eyewitnesses, then the insanity defense may be his best and only option.
Turning now to Nashville, Tennessee, where jury selection is underway for the trial of 32-year-old Travis Reinking. Opening statements are expected to begin Monday, and we are going to bring them to you live here on Court TV. Reinking is accused of opening fire with his AR-15 semi-automatic rifle at a Waffle House, killing 4 people and injuring several others in April of 2018. The gunfire ended only after a restaurant customer wrestled that rifle away from Reinking, who then fled from the scene naked. Court TV legal correspondent Chanley Painter has a closer look at the background of this case.
4 people are dead and there are more victims.
It has been more than 3 years since residents of Nashville woke up to news of a mass shooting. It was at a local Waffle House. 4 dead and 4 others injured, 2 by gunfire.
Both of those victims remain in critical condition here at Vanderbilt University Medical Center.
There could have been more casualties that morning had it not been for this man.
Even though I feel this pain in my hand, it still doesn't feel real.
James Shaw Jr. had just sat down at the restaurant when the gunman started shooting.
His gun either got jammed or he was trying to reload, and then we started kind of wrestling for it and scuffling and fighting for it. And after he let it go with one hand, and then when he just had it in his other hand, I just took it and I tossed it over the counter.
The suspect was identified as Travis Reinking. He was known to police for a number of run-ins, including one at the White House in July 2017. Reinking was arrested for trespassing after venturing into a restricted area.
He shows signs of significant instability. Yesterday, the police department recovered 2 long guns from the apartment. We also obviously have the AR-15. There was a 4th gun, a handgun, that is unaccounted for.
Authorities launched an intense manhunt for Reinking, fearing the potential for more violence.
The crime he committed, a quadruple murder, there's nothing more urgent than that, to find the person responsible.
Reinking was captured a day later, but his trial on murder charges was delayed while attorneys raised questions about his mental health. Reinking has been ruled competent to stand trial, but his lawyers are expected to argue he was insane at the time of the shooting and could not appreciate right from wrong. Among the witnesses that could challenge that premise is James Shaw Jr., who battled Reinking for his rifle.
People say I saved a bunch of lives, but there's still, people that died, so it still kind of hurts. And I saw those people, so it's a little difficult.
Still with us, trial attorney Vonda Sargent. Vonda, let's talk about the difference between competent to stand trial versus an insanity defense. And so when we start at the beginning of the story, the first thing is whether or not he's competent to stand trial. At this point, he is. Trial's expected to start Monday. We'll be there live. Is there any possibility that at the time a trial starts, that a defendant might then be found to not be competent to go forward with trial after all?
Yes, that is a possibility, particularly if he stops taking his medication. I'm unclear if whether Tennessee has compulsory, where they can force him to take his medication, but if he stops taking his medication, he could be deemed incompetent to stand trial, and the trial could be placed on hold indefinitely or until they get him back into competency, which is getting him back on his drugs and on his medication regime. So that is a possibility for that to occur in this case.
And in fact, Lori Vallow, which we know is the doomsday cult case, in that case, we know that she has been deemed not competent and then she'll be reevaluated. I think it's every 90 days. So assuming that he's still competent to stand trial on Monday, now if you would differentiate for us the difference between competent to stand trial, he is, we start trial, and the insanity defense and what that means as a trial attorney.
Well, what that means is that his attorney is going to have to prove to the jury that at the time that this crime took place, that he was incompetent, that he did not know the difference between right or wrong, that he was basically the chemical imbalances in his brain were such that he was unable to differentiate between what was right and what was wrong. So he could have had people speaking to him, he could have been seeing things, whatever it was that was going on with him, they're going to have to prove that up through various forms of evidence. It could be his neighbors, it could be his family, it could be him, in fact. So that's the difference between competent and insanity in the legal sense. And the difference with the punishment would be whether he spends time in prison or whether he spends time in a mental health facility.
Great point with the difference in the punishment. In this case, will there be facts that are used in determining whether or not he was insane or insanity defense at the time? And here's what I mean by that. What is reported is that he was in his vehicle before he went into the Waffle House. And if I were an attorney prosecuting, I would argue premeditation. He was sitting, he was thinking about it before he went in. And another fact that I think I would use if I were the defense was he had a green coat on, and then when he fled, we know he fled naked. Are those individual facts things that can be argued by each side in establishing for this jury whether or not the insanity defense should hold?
Well, as you know, Judge Ashley, my bent is towards the prosecution, so absolutely I would point out that while he was sitting in his car, he wanted the maximum number of people to be in the restaurant. He wanted to scope, he was scoping out where people were situated, particularly where the men were situated, where people were situated, so he could know how and where to plan his attack and who to shoot first and where to aim his weapon. So I definitely think that is going to be one of the factors that the prosecution is going to rely upon. I'd also rely upon my hero and what it was that he saw Reinking doing, what he heard Reinking say, the look on Ranking's face when he confronted him. So I'd also use those two would be my strongest bits of evidence. The fact that he didn't have on clothing, I would turn into the fact that he didn't want to leave any evidence of his person, any fibers from his clothing on the scene. And in the midst of trying to flee, the overcoat was taken from him. So that's what I would argue.
I got to tell you, there's that prosecution perspective on why he wasn't wearing any clothes. So good arguments, all of them, if you're representing the state in this case.